I would like to take the permission of all the judges before beginning the session.
Yes.
Nakul sir, can we begin?
Yes, Garima. Totally, I'm here to begin.
Welcome to the final round of the second virtual international mediation competition organized by MediateGuru. This round is between Team VIMC02 and Team VIMC41. I would like to congratulate both the teams for reaching this far. I am Garima Rana and I will be moderating this session. I would like to thank this opportunity to all the worthy participants and thank you esteemed judges for volunteering their valuable time. We have Ms. Reshma Ogra. She is an international arbitrator and legal counsel alongside sitting as arbitrator and acting as counsel in arbitration and mediation proceedings. She advises on risk management, conflict prevention, avoidance and resolution for businesses involved in technology, construction, and international trade and investment. Over the course of her career, Reshma gained experience in multi-jurisdictional matters, has worked in the United Kingdom, Mauritius, Saudi Arabia, Qatar, and the United Arab Emirates, and has represented clients in Oman and Kuwait. Her independent legal consultancy, Neom Legal, is a digitally native legal solutions provider registered in the UAE and serves businesses from all around the world. Next, we have Ms. Amrita Tonk. Ms. Amrita graduated in 2010 and joined L&L Partners, which was formerly known as Luthra & Luthra Law Offices, as an associate with the legal estate team. Therefore, she shifted to a secondment position at Accenture, wherein she closely worked with the legal team from March 2012 to March 2013. In 2013, Amrita secured the 7th rank in the prestigious Delhi Judicial Services examination and served as a Metropolitan Magistrate in Delhi. During the course of her tenure in the Judicial Service, she presided over criminal courts in Patiala House and Tisazari courts. She resigned from the Delhi Judicial Services in January 2018 and focused on her independent practice. In 2021, she was offered a position as a partner in the dispute resolution team at L&L Partners Law Offices. As a partner, Amrita is primarily involved in advising and representing clients, property disputes, consumer laws, matters related to negotiable instruments, matters related to intellectual property, matters under writ public interest litigation, white-collar crimes, including corporate frauds, offense under the Indian Penal Code, and anticipatory and regular bail applications. We have Ms. Kathleen Luanalidi. She's a mediator at Pierce County Center for Dispute Resolution. She's first court jurors, United States. She's a former divorce mediator at Norfolk Probate and Family Court. She's former coach and training coordinator at Family Services of Central Massachusetts. She's a former summary process mediator at Quincy District Court. She's the former summary process mediator at Quincy District Court. She's the former small claims and divorce mediator at Plymouth Family and Probate Court. She's the former claims and summary process mediator at Cape Mediation. She's the former executive assistant to CFO and VP at Ram Power Corporation. She's the former health educator at Greencastle Antrim School District. She studied Master of Education at Shippensburg State University. She studied Health and Physical Education K-12 at Shepherd University. We have Mr. Nakul Sachdeva. He graduated from Indian Law Society Law College, Pune, and began his career in litigation in the chambers of Mr. Amarjeet Singh, the then Additional Solicitor General of India. He subsequently joined the City Civil Courts team of Karanjawala and Co. in the year 2009. Nakul Sachdeva joined LNN Partners, which is formerly known as Luthra and Luthra Law Offices, in July 2018 as partner designate and was elevated to a partner in November 2019. Since joining LNN Partners, Mr. Sachdeva has been extensively and actively involved in significant matters relating to the Arbitration Act, as well as insolvency and bankruptcy code, and regularly appears before various NCLTs and LCLATs and the Honorable Supreme Court. In the last 2 years, Mr. Sachdeva has ably advised and represented resolution professionals. Just a second, so sorry. In the last 2 years, Mr. Sachdeva has ably advised and represented resolution professionals, resolution applicants, as well as the COC in numerous corporate insolvency resolution process, where in most of the cases, State Bank of India has either been a lead bank or a member of COC. Given his diverse and rich litigation experience, spanning well over a decade, and dealing with a wide multitude of laws, Mr. Sachdeva brings to the table his comprehensive set of skills and insightful appreciation of complex legal issues. I would like to thank once again to all the judges and extend my gratitude of Mediate Guru towards the respected judges, and with the permission, we shall begin by the opening statement of the mediator.
Good evening to everyone here today. And I have to say that it is wonderful to see both parties at this mediation table this evening. I would also like to extend my thanks to all parties as well for accommodating this online mediation session. I would also like to emphasize that I note that this is a big step for IBGF and Boxstar, and I would like to thank you again for making time to come to this mediation table. So welcome to your mediation. Allow me to introduce myself. My name is Darius Lee. Please call me Darius. I'll be co-mediating with my fellow colleague, Taylor. Taylor?
Namaste. My name is Taylor. I'm from India, and in India, Namaste is a form of greeting. Therefore, I extend a very warm greeting to each and every one of you here. It's a pleasure to be co-mediating this session with Darius. I would just like to hope that each one of you are safe and well in these unprecedented times of the COVID-19 pandemic. And we hope that this session will be fruitful for everybody present here. Thank you. Darius?
Thank you, Taylor. So may I ask, what are your names and how would you like me to address you? Perhaps we could start with the requesting party, followed by the responding party.
Good evening, everyone. I'm Vijay Singh, the Chief Executive Officer of IBGF Private Limited, or just IBGF for simplicity's sake. I would like to be referred to as Vijay in this session today. My preferred pronouns are he or him. It is a pleasure to be here, and I'm really looking forward to a fruitful session ahead. Thank you so much.
Good evening, everyone. I'm Neha, and I'm the counsel for Mr. Vijay Singh. My preferred pronouns are she or her. You can refer to me as Neha, and I confirm my authority to represent IBGF Private Limited in this matter. Thank you.
Thank you, Neha. Could I just clarify, is it pronounced as Mr. Vijaya?
Yeah, it's Vijay.
Could you assist us in putting your name in the chat, so for the sake of clarity for everybody? Thank you so much. Could we hear from the responding party?
Good evening, everyone, and namaste. I'm Hillman, CEO of Boxstar. You can refer to me as Hillman. Thank you so much.
Hi, everyone. I'm Ashley, and I'm the counsel for Boxstar, and I'm happy to see everyone here today. Thank you.
Thank you, Vijay, Neha, Ashley, and Hillman. So before we proceed with this session, can I first quickly check if each of you are capable to make decisions regarding the resolution of this matter, should you deem it appropriate? Just a quick thumbs up will do. Thank you for that. So for the commencement of this mediation, I will first start with my opening statements, followed by that of Taylor's, so that we are all aware of the tone and the processes that will occur. Mediation is effectively a negotiation with the assistance of a neutral third party, with the goal of coming to an amicable solution to the problem we have at hand. To me, mediation is akin to a lighthouse, and parties at this juncture are ships out in the open sea navigating a storm. With the lighthouse as a beacon of light, I'm confident that parties will be guided and emerge out of the storm and dock in the safe harbors once more. That said, just like a beacon of light, this mediation session is not meant to pressure any party to take any stances, but merely provide a platform that is both transparent and efficient for parties to reach a mutually beneficial outcome. I want to assure you that my role here is to exclusively facilitate communication between all parties and to partner both parties and assist you in re-evaluating your own positions as well as that of the other party, with the intention of arriving at a resolution that both parties are happy with. So now, before I hand my time over to Taylor, I would just quickly send the link to the Zoom session in the chat in case we get bounced out, because I do note that this is an online mediation session, and and there may be internet disconnections that may bounce us out of the session. So without further ado, Taylor.
Thank you so much, Darius. First of all, as mediators, we will not be serving as advocates or judges. A mediator's sole function is to act as a neutral person, like Darius said, who facilitates your conversation. As third parties who are not directly involved in the matter, we will assist you by guiding your conversation. We will not be taking any sides during the session, and we have no power to force a decision on you or decide how this matter should be settled. We'll be playing a neutral, impartial, and non-adjudicatory role. Today, we'll be following the AIAC rules as mentioned in the proposition. And according to this, Rule 6 states that each mediator should show their statement of willingness and impartiality and independence. Here, I will just share my screen quickly for a second to show you the statement of independence. Is my screen visible? I will also be sending the file to you on email, so you have a copy. Moving on, mediation is essentially a confidential process. No statement made here by anyone can be used for or against a person in a court of law. As mediators, neither of us will divulge any information that you confide in us today. Furthermore, neither of us can be called to testify on behalf of either party. Both Darius and I will be making notes during this session, as well as several agreement drafts, should there be any agreement that takes place today. But these are all confidential, and our personal notes will be destroyed after the session. Furthermore, any written material that one party does share with us with the intention that it is not shared with the other party shall be clearly labeled as confidential for mediators' use only. I suggest that both parties enter the session with an open mind and a willingness to cooperate for deriving the best results out of the process. This is a completely safe space, and I hope this session is fruitful for everybody. No information provided orally by a party to us during a separate meeting may be disclosed to any other party by us unless you explicitly so authorize. Now, just a couple of ground rules before we get started. We expect that you will be patient, you will speak honestly and bargain in good faith. We found it easier in our experience to hear if only one person talks at a time. So please refrain from speaking over each other. And if one person is speaking, all the others must remain muted. Also, as per Rule 9 of the AIAC rules, both parties must respect the process and our roles as mediators. Each party has a duty to participate in good faith in the mediation, and each party and their representatives will use their best endeavors to cooperate with each other and with us to resolve their disputes amicably and reach a settlement agreement. The process which we'll be following today will be as per Rule 11 of the AIAC rules. First, we will be giving our opening statements in this joint session. And then once our opening statements are completed, we will be continuing with the joint session where you will provide your opening statements. Following that, we will begin the joint conference. A caucus or a private session may also be called should the need arise. And this private session carries within an extra layer of confidentiality in addition to the confidentiality provided to you in the joint conference. So everybody here is here out of their own volition. And if you do feel uncomfortable at any point of time, please let either Darius or I know. Just a recap of our last session. First of all, I apologize. We were supposed to have our last session on the 24th and 25th of March, but due to some logistical constraints, we had to postpone the 27th. Thank you for accommodating us with the dates. As a recap of the last session, I'm sure you remember you entered into a confidentiality agreement. For the clarity of everybody here, I will just quickly share my screen again of the confidentiality agreement that has been emailed to me by your advocates.
Thank you. Before Taylor continues, perhaps I could just quickly summarize parties' three entitlements. Firstly, on neutrality, secondly, on confidentiality, and lastly, on voluntariness. And what we both, as co-mediators, request of you is that with these entitlements that you have, we would appreciate if you could abide by the two main ground rules that no one person will speak at any one time. And secondly, this participation in this mediation session will be conducted and treated in good faith. Now, sorry, back to Taylor.
Yes, absolutely. This is the confidentiality agreement that you entered into at our last discussion. I'm sure you'll find it suitable. I will also send this to you on your emails. So without further ado, I think, Darius, if you don't have anything to add, we may begin with our joint conference and the parties may begin with the opening statements. Perhaps we could start with the requesting party followed by the responding party. Okay, thank you.
First of all, I hope everyone is doing well and taking care of themselves and their friends and family in these tough times of the pandemic, as Taylor has mentioned, which has necessitated this mediation session to be on a virtual platform. Then secondly, I would like to thank the mediators for explaining this process of mediation so lucidly. And I would also like to pay my thanks to Hillman and Ashley for agreeing to the second mediation session, where hopefully through mutual collaboration and negotiations, we'll be able to resolve the issue that we are currently facing. So in the previous mediation session, as our mediators have so kindly summarized, we had covered some very substantial grounds. And I would like to again pay my gratitude to Hillman and Ashley for agreeing with us on the confidentiality agreement and the requirement of a mediator to facilitate the process along, including the settlement of the dispute in terms of the distributorship agreement and with respect to the legal actions arising therefrom. So a brief recap of what I had already mentioned in the first session for the benefit of everyone present here, that IBGF Limited was founded in 2000 by my dear father, Mr. Satish Singh, almost 2 decades ago. But honestly, it feels like only yesterday when in a small colony in New Delhi, a small business venture started with huge ambitions to distribute computer hardware products in India, Germany, and UK. Since 2019, after he retired from his position owing to some health conditions, I have been in control of the company and looking after its daily operations. When we were approached by Boxstar to get into an agreement regarding the distribution of their Grand Robbery Auto series, or the GRA series as we like to call it, we were positively ecstatic to get to work with such a huge and well-established computer hardware manufacturer was a huge milestone in our business sojourn. But as we know, there has been an impasse in our relationship owing to shipping and distribution and certain breaches of the terms of the contract that we had agreed upon initially. And we are here today to continue our discussion regarding the same and further the common grounds that we had reached in the first mediation. As per the initial agreement, IBGF had the rights to sell the GRA series in UK, India, and Germany. But then Boxstar insisted on retaining the exclusive rights to sell in the territories of Germany and UK, to which we had to reluctantly agree because we did not want to miss out on this business venture with Boxstar. But this step left IBGF with only India, where we could sell the said gaming series. It must be pointed out for everyone's benefit that even though Boxstar insisted on retaining the rights to sell in UK and Germany, there was no change in the contract per se, which still officially provides for us to sell in all the 3 assigned territories. Our target was to sell 3,000 units of the gaming units, and which amounted to 1.5 million US dollars in the assigned territories of UK, Germany, and India. But since we were only left with India, we could not reach the set target. But thanks to our distribution team and the loyal network that we have established over the years, we did manage to sell 2,000 units of the game in 1 year, that too only in India, which we consider an undeniable feat in our own right. Owing to some legal review, there was a delay of about 8 months in shipping the first 1,000 units of the GRA series that we had ordered immediately after the agreement in January 2019, but received it in August 2019. Another point to note is of the issue regarding the upgraded GRA 2 series that Boxstar introduced in February 2020 and discontinued the original GRA series. But as per the agreement, we did have the right to sell the Boxstar Grand Robbery Auto series and any updates thereto. And all of these legalities, I'm sure Neha will deal with when she presents her opening statements. So therefore, I believe it was reasonably stipulated in the contract that IBGF will have the rights to distribute any upgrades of the GRA series, which includes the GRA2 within its ambits, especially in the absence of any notice or official statement to the contrary. Also, it is reasonable to believe that IBGF would have the rights to sell to on this upgraded series in order to meet the target of 3,000 units, seeing as how Boxstar discontinued the original series. Thus, the initial refusal by Boxstar to allow us to sell the upgraded version and their consequent retraction of the said refusal did indeed play a major role in our distribution of the gaming units and why we could not manage to reach the stipulated target. Because of the delay and the lack of clarity regarding some of the terms of the contract, we have had to face major losses and actual damages that have been incurred to our company, our team, and all the linkages that we have. Also, with regards to the termination notice, I would like to emphasize that as with the contract, if an agreement were not achieved, either party had the power to terminate a contract upon prior 90 days notice. But Boxstar, without prior warning, issued us the termination notice 30 days prior instead of 90. Thus, I have been advised by my counsel that this termination notice by Boxstar itself is of dubious legal validity. I hope that I have outlined some of the major issues that we have had with regards to our business relationship with Boxstar. And of course, the legal details, specifics, and technicalities will be filled in by Ms. Neha, the legal counsel for IBGF, and my very dear friend. And we have come to the second mediation table again with an open mind, a wide outlook to understand the concern from your end as well, Hillman and Ashley, and to put forth ideas and offers on the table and understand your take on them and to chalk out an amicable solution that would benefit us both in the future. I'm really looking forward to a productive session ahead. Thank you so much.
Thank you, Vijay. I thank the mediators, Darius and Taylor, for wonderfully explaining the process of mediation and allaying the fears of my client. I'm Neha, the counsel for IBGF Private Limited. At the outset, I would like to confirm my authority to represent IBGF in the matter concerned. I'm here to help my dear friend Vijay, with whom I've been associated with over 2 decades. I thank Hillman and his counsel Ashley to have agreed to come to this table and solve this joint issue. The discussion at hand, as had been agreed upon in our first mediation session, involves the distributorship agreement between IBGF and Boxstar, which involves certain complex terms and conditions, and also the subsequent termination of this transaction and the issues revolving around the same. The discussion ultimately is a legal one, and my role today would be to deal with such legal technicalities in this session. I would like to clarify that I'm not here to make any legal arguments. I'm here to only protect my client's interests. I'm here to check the legal soundness, the validity, and the correctness of the solutions brought to this table. So I'm here in an advisory capacity, considering that we would be discussing the terms on breach of contract, the future business strategies, making offers and entertaining counter offers and deciding on numbers. So what we are going to discuss are the core terms of the contract, and I'm here to deal with such intricacies. IBGF looks for continuing its amicable relationship and establishment of trust with Boxstar, based on which the agenda we would like to set down today is two-pronged. First is to discuss the breach of the exclusive dealership agreement and the associated damages. And second is to discuss the continuation of our business relationship. Some of the discussions might overlap, and we request the mediators to take care of the same. We hope to have a very productive session and look forward to finding a common ground that not only resolves our current interests, but also stands the test of time. Thank you very much.
Thank you so much, Vijay and Neha. I would like to thank you for your willingness to come for this mediation and your desire. I can sense your desire to achieve a mutually beneficial solution coming out of this mediation session today. So from what I understand, your two main interests are firstly on the agreement surrounding the distribution rights, and secondly, the continuation of this synergistic relationship between parties. May I check if this is correct? Thank you so
Yes.
much. Now, perhaps it'd be good time for us to hear from Ashley and Hillman on your outlook on this matter today.
Hey everyone, it's good to see everyone here at this mediation table today, so committed to, finding a way forward together, especially with especially considering the positions both our companies are at the moment. Before moving forward, owing to the medium of this mediation taking place online and perhaps the differences in our region, could I ask if we all could slow down a little bit when speaking, because I really did try to listen as well as I could to Vijay and Neha just now, but I think there were a few points that I couldn't catch. But anyway, moving on. Darius, like you mentioned just now about how mediation is like lighthouse. A lighthouse brings ships back from troubled waters. I completely agree. And I know that Vijay agrees too. While I'm hopeful that we find a solution that ensures our way forward together, I want to make sure that what we agree on meets everyone's interests as much as possible. It would be amazing if we could get through these troubled waters together and get back to welcoming shores for our future. I thank Vijay for his perspective on the events that have brought us to the table today, but I would also like to share my perspective on what my company has gone through since the first agreement was signed. Boxstar is a well-established, award-winning computer hardware and computer peripherals manufacturer looking to expand all over the world. This is a big reason why we engage with distributors and why we chose IBGF to assist us on taking on the territories in India, Germany, and the UK. We saw the potential that IBGF had, especially when we were told that you had connections to the big markets in India, Germany, and the UK. We were hoping that the relative youth of your company would not pose such an obstacle. We were happy to allow for a little leeway for your company in the contract. We had set our goals quite clearly, and we relied on IBGF to do their part in bringing both our companies success. The GRA series had such an amazing potential too, and we were excited to see it hit the markets. So you can imagine my disappointment when even 2 years after the contract was signed, IBGF failed to even meet the minimum non-cancelable order that we agreed to at the signing of the agreement. It was even more disappointing when we are yet to see the distribution network that IBGF had just in India. At June 2020, only consisted of 3 other distributors. When we called for the termination of the contract, we were frustrated by the lack of progress being made on your part. We believed that we had every right as a profit-driven company to seek termination of this contract. I was shocked when I received the news that IBGF issued a letter of demand for damages amounting to $3 million US. To put that in perspective, that is twice the amount that IBGF had agreed to purchase from us in that 3,000 units. In any event, while I'm looking forward to seeing if we can work together in the future, I'm mindful of the precarious nature of our current situation. I'm looking forward to the discussion that we'll have today. So I'll pass my time to Ashley, my counsel.
Thank you so much, Hillman. Good evening, everyone. I'm Ashley, and I'm the counsel for Boxstar. And I'm here today to represent a legal point of view for the discussion here and also defend my client's interests. I'm heartened to see everyone in today's mediation, and I'm sure Hillman and I really appreciate you taking time out of your busy schedules to attend this session. And I would also like to thank Darius and Taylor for agreeing to mediate this session. Well, as you can see and as you have heard, my client is very committed to this negotiation, and he sees this as an excellent opportunity for us to clarify any misunderstandings and resolve any hiccups between both parties. Given the partnership between Boxstar and IBGF, I'm sure you can comprehend the disappointment and shock that my client is currently facing when $500,000 of unpaid goods is on the line, to which end, I'm sure we can agree that it's not a small sum. Additionally, the letter of demand that we received from your company has made my client feel that the trust between our companies has been damaged. Having said that, we would like to be as open and transparent as possible. And that means, well, we do have to acknowledge the commercial reality of the situation. And that is that my client is a profiting entity just like yours. And I sincerely hope that Vijay and Hilman can come to an agreement here today. The last thing that we would want is to be placed in a situation where our hands are tied and will have no choice but to resort to proceeding on with litigation. And in spirit of this negotiation, my client will have no choice but to do so if we're unable to come to an agreement here today. Again, I'm only bringing this up because I believe having this out in the open will make today a more productive negotiation session. So, what does a good deal look like to us? A good deal to us encompasses 4 points. Firstly, an arrangement for an establishment of a satisfactory distribution network. Secondly, an agreement on a minimum annual order amount. Thirdly, a payment for the unpaid goods. And lastly, a continuing good relationship with IBGF with a good plan on growing together. And with that, we look forward to a productive session with you today.
Ashley, before we move on, could you please repeat the third point that you just mentioned?
Sure. The third point is the payment for the unpaid goods.
Thank you so much, Ashley. Ashley, I'm afraid that your voice cut out for me while you were talking about the 4 points. I got all the points of the second one. I'm very sorry, but can you please repeat the second point?
The second point? Would you like me to just repeat all 4 points? Okay, so
whatever you're comfortable with.
All right, so a good deal to us would encompass 4 points. The first one being the arrangement of an establishment of a satisfactory distribution network. The second being an agreed minimum annual order amount. The third, as I've said earlier, is the payment for unpaid goods. And the fourth one is a continuing good relationship with IBGF with a good plan on growing together. Is there anything else I could clarify?
Oh, thank you.
Thank you.
Thank you both Taylor and Ashley and Hillman for that wonderful opening statement. We definitely commend both of you for having some hopeful and positive outlook to today's session. And rest assured, we do take note of the disappointment and the shock that you faced. Moving on, just to clarify, you have 4 major agenda points here. First, which is the arrangement of a satisfactory distribution network. Second is the agreeing to a minimum annual order amount. Thirdly, the discussion on the payment of unpaid goods. And fourth, the continuance of good relationship. I think I will hand it over to Darius, who will now set forth the agenda.
Thank you so much for the wonderful opening statements as well as the very comprehensive summary by my colleague. So if I may proceed to share my screen. So these are the points that I've taken down previously in the opening statements as to what may be the discussion points that we want to talk about in the mediation session today. So just to run us through, I heard from IBGF 2 main points on the distribution rights agreement, as well as prolonging working relationship, as well as I heard from Boxstar 4 main points on the establishment of a distribution network, a minimum order amount, outstanding unpaid sums, as well as prolonging the working relationship. So if I may, if parties allow me, I could propose a broad and neutral agenda headers firstly on calibration, secondly on collaboration, and lastly on continuation. So let me just bring us through why this agenda. So firstly on calibration, I think that this is suitable as parties, by knowing each other's constraints, can calibrate their expectations during this session. And this nicely ties into our second agenda header point on collaboration, because obviously parties do have their own solutions in mind. So perhaps under this point of collaboration, parties can see how they can work together to achieve a mutually beneficial and mutually agreeable collaborative method. And lastly, on continuation, it wraps up our whole discussion nicely, as continuation nicely ties in how parties would like to prolong this synergistic working relationship. So we want an all-encompassing agenda. So perhaps my colleague Taylor can help us in putting down the substantive discussion points under the broad agenda headers. So before I move on and pass my time to Taylor, are parties agreeable with this broad agenda framework?
Darius,
Thank you.
if I may.
Yes.
Sorry.
Yes.
If I may, then under the distribution rights agreement, just to make it clearer, we would like to discuss the breach and the damages that we have incurred. So if you could just add that for the clarity of everyone present here.
Breach and so you were talking about the damages that have been incurred, right? Could I park that under the neutral header of financial concerns?
Yes.
Thank you. So if Taylor, is it okay if you assist us in finding the common grounds between both parties' discussion points, and we can park that under our broad agenda headers?
Absolutely. From what I observe here, we have, like Darius mentioned, these 6 major broad headers for the agenda. From this, we observe a particular theme relating to the distributorship agreement, which could be the first agenda. But before we set out the order of agendas, I would like to ask you parties, what is the agenda that you would like to talk about the least? We could take that up last. Like,
I'm sorry,
what agenda
if I may just quickly chime in, I think it's apposite for me to remind parties that, an agenda is a fluid entity. Definitely, we are not discussing any things in particular manner of importance. And, we can change our discussion direction at any point of time. But of course, if parties would like to discuss certain discussion points at the get-go, most definitely, I think Taylor and I will be agreeable with parking that first.
Yes, moving forward, what is the agenda point that you would like to talk about, let's say, last in the order? Perhaps the requesting party also. Yes.
Yeah. I do not believe I have something that I would like to discuss at the end. Honestly speaking, we would like to cover everything, but due to paucity of time, maybe my council could recommend something that is more priority to us.
Yeah, so instead of asking what we would like to discuss the least, we would like to discuss the breach and the financial concerns the first, and then move on to our long-standing, the continuing relationship, which may overlap, and I think the mediators can take care of it.
If I may, would parties allow me, because I do sense that we have a common ground on prolonging the working relationship. So I think this nicely ties into the agenda header of continuation. So are parties amenable if I park this discussion point under this agenda header of continuation?
Yes, sure, that is.
Yes.
Right. Okay. So we can strike this out because we've already included that in our agenda. And so on the 3 remaining points on establishment of your distribution network, minimum order amount, and outstanding unpaid sums, I sense that an establishment of a distribution network seems to be like a form of collaboration. So if Boxstar is amenable, and of course if IBGF is amenable, could I park that under the second agenda header of collaboration? Would that be possible?
Yes, actually, if I may just chime in, I think the 3 agenda points that we've brought forward seem to fall under collaboration really more suitably. But I would just like to also point out that we do want to take the opportunity to hear IBGF's point of view, and also to clarify certain misunderstandings or conflicts that we might have regarding these matters. So if it's possible, would we be able to include another point under calibration where we could talk about the termination of the contract, which I think these 3 points do fall under?
So is that right if I say that the point of termination goes under the distribution rights agreement? It's a sub point.
Yeah, that's fine.
Right. So are parties amenable with this agenda we have on the board right now? Just a quick thumbs up will do. Okay. Ashley, is that okay as well? Okay, that's good. So I think we do have an agenda at hand now. So if anyone can take us off on the first agenda point on calibration, specifically on the distribution rights agreement.
Hi, if I could get us started. If you could help me understand, Vijay, you mentioned that there was a breach on Boxstar's part. Could you help me understand what you viewed as a breach?
Yes, sure. So as per the agreement, we had the exclusive rights to sell, and apologies for speaking fast in the opening statements. I'm sorry. I'll try to slow down because this is something which is very important to us. So maybe I go with the flow sometimes. So to answer your question, the breach that we believe, and this is very technical, so maybe Neha could explain it in a better manner. But just to answer, we had the rights, exclusive rights to sell in UK, Germany, and India. But then there was the Boxstar retained those rights, and then we only had the rights to sell in India. And that is something that we consider some sort of misunderstanding, or maybe it was not done in a way that would stand the test of time or like stand the future relationship. So first that, because we did not change the official contractual terms. And I did not, nor did any of my agents or any of my counsels. So that is something that we would like to discuss. And seeing as how you were disappointed that we could not reach the target, Hillman, first of all, we were only selling in India. And because of the delays, because you had the legal department review the agreement, if I am correct on that regard, and then you issued a new upgraded series. And also, as per the agreement, IBGF did have the rights to distribute the new series, because the agreement says that the Grand Robbery Auto series and any updates there too. So that is why I was under the impression, as was my counsel, that we would be selling the GRA2 series as well. But then you refused us the rights to distribute those, but then there was the retraction of the refusal. So that is something which may not necessarily be a breach, because that is a legal term that I believe Neha could explain in a better manner. But those are some things that restrained us from actually achieving the target of 3,000. And in my opinion, achieving 2,000 target only in India with the delays in the 2 years gap that we have been in agreement is a very commendable feat in my opinion. And I understand your disappointment that we could not reach the set target, because we were both very excited about this new contract that we entered into. I remember how happy we were that day. So that is what is my take on this. If Neha could please explain the intricacies, the legal aspects.
Yes, Vijay. So as Vijay already mentioned, I would like to draw your attention to Clause A of the contract, which provides for the sole right to IBGF for any updates relating to the product, which is the GRA series, which clearly indicates that IBGF had the right to sell the second series of the gaming product. This was, however, denied, and there was a significant delay based on which the dealers had to incur running costs and losses. Because although IBGF reluctantly agreed to it because we wanted to maintain the long-standing relationship, it ultimately ended up curtailing IBGF's market reach to UK and Germany, considering that UK, Germany, and India are approximately of the same markets, providing us with a huge market size. This is one thing that we wanted to point out. Because of these delays and a lot of other problems that we had to incur in these years, the target of the non-cancelable order of 3,000 units was set up in keeping in mind the fact that we could be getting access to all the 3 territories. And as my client already mentioned, achieving 2,000 units in India is a commendable job. And also, however, IBGF does acknowledge the fact that IBGF had not revised the annual purchase commitments. However, it was due to the hardships that we were undergoing due to the delay, because of which we were also unable to revise our annual purchase commitments. I would like to hear the opinion of Ashley and Hillman on this.
All right. If I could just chime in. So there seems to be have a lot of things said, and I think my client's question just now was just simply on what the breach exactly was. And I think to that you've mentioned that it was that we allowed for sole, what is it, in clause 1, right? In clause A, sorry, is that IBGF shall have the sole right to sell Boxstar RGA series. And I think that you've mentioned that we have taken that right back. And I think our understanding of what actually transpired was that while IBGF has the right to distribute in those 3 territories, which is India, Germany, and UK, that it was just that my client had mentioned that we do also have the right to distribute this RGA series too. So I think on that note, there seems to be some miscommunication. And Hillman, do you have anything you want to add on this point?
Yes, certainly. I think that was it seems that is the misunderstanding that we have when we, in that clause that you pointed out, except for Boxstar was included. There was nothing, to my understanding of it, and actually if you could confirm this for me, there was nothing precluding IBGF from also entering those markets with us. When we are a manufacturing company, essentially. So when we took into consideration that IBGF is also a relatively young company, to be able to take on these 3 large markets certainly is a feat. So we had asked for your assistance in exploring these markets. There was no, to my mind at least, no indication that we were precluding you from entering this market and helping us explore these markets. So if this is something you could help us understand a little bit better from your point of view, that would be fantastic. Ashley, I asked you to help me confirm something. Can you help me do that?
Yeah, so as my client has mentioned, that seems to be the understanding that we had. And I think at this juncture, there seems to be a misunderstanding of what actually transpired. So mediators, do you think it would be possible to call a caucus?
Hi, Ashley.
Absolutely.
Most certainly. Oh, so sorry, Taylor. If I may. Oh yeah, most certainly. I think before we go into the private session, let me just quickly sum up what was being discussed. Because I think a lot has been said. We were discussing on the agenda header of the breach, and I think Taylor and I heard a lot of different interpretation of clause A of the distribution rights agreement, and I think that Ashley has rightly called for a caucus, because I do sense that like our mediation session has been going around about the interpretation of the clause, and I don't think that this goes into the spirit of mediation. Definitely, we want to gather each other's gather information on each other's underlying constraints. So I think any discussion on any legal positioning may not be the most fruitful in this mediation session. So I think it'll be a good time for us to go into a caucus session like Ashley requested. Would Vijay and Neha want a caucus session after theirs as well? Okay, thank you. Moderator, could you just bring us into the private session? Thank you.
Perhaps, I'm so sorry to interrupt. Perhaps you want to start with the requesting party, or would the responding party like to go first?
I think we would be happy to let the requesting party go first.
All right, thank you so much. Madam Moderator, can you please help direct us to the breakout rooms?
Sorry, moderator. I think we have the responding party in the room right now. I think we, as parties agreed, we wanted to have a caucus with the requesting party first. Hello,
so
Vijay and Neha. Sorry, Taylor, is there anything you would like to add before I begin?
Yes, I think we should definitely begin the caucus. I was just thanking the moderator.
Okay, thank you. So before we begin, I would first like to assure you that everything you tell me here remains confidential. This caucus will also be an opportunity for me to find out how I can assist you in moving this discussion forward. I also want to remind you that if you want something to be disclosed, you will need to give me permission to disclose it. So so how may I help you actually? If you could tell me, because I do hear a lot of discussion on the overlapping interpretations of the clause A of the distribution agreement. So could I hear more on that?
Yes, if I make clear, in the general caucus, there was a confusion. I had pointed out to two things in clause A. One was relating to the updates. Though it reads that any updates thereto. So updates, as we interpret, includes the upgraded version of the product as well, which essentially gives the exclusive rights to also IBGF to sell the second version of the gaming series, which was, however, delayed by Boxstar. That was one thing we wanted to point out. And a second thing, we do agree that Boxstar also has the right to sell the gaming series. However, all we wanted to point out is the fact that since we were not given, we were told to restrain from selling directly in Germany and UK, we had to restrain our market only to India, because of which we were not able to achieve the targets set. Right. So this is the reason we just wanted to point out that the targets could not be achieved because our market access was restrained. And one more thing we wanted to point out also was the notice of termination, which was we were served a notice 30 days prior instead of 90 days. So these are the few things we wanted to highlight in light of the breach of contract. I think my client Vijay could further elaborate on it.
I'm really sorry, just to interrupt for a minute here, Vijay. I would just like to confirm the three major points that you're concerned with. First, it is regarding the word updates as in clause A of the agreement. Second is regarding Boxstar having the right to distribute in UK and Germany, and your market was restrained just to India, which caused you to have a smaller distributing network. And lastly is the notice of termination, which was supposed to be 90 days, but was given to you just 30 days prior. Am I correct?
Yes, certainly.
Thank you so much. Sorry, Vijay, please go ahead.
No issues, Taylor. But I believe Neha has really very succinctly put forth what I was trying to explain in the general conference. But her being a counsel, she was really brief and to the point. So I really thank her for that. And so far, I believe we have been trying to understand each other's position. And Hillman and Ashley have really been candid, in my opinion, about the disappointment and shock. But I had wanted them to be a bit more understanding, because there does seem to be some miscommunication regarding the word updates and whether we had the rights to sell in the UK or Germany. So that would be something that I would really be interested to discuss further when we go back to the general conference. Our main agenda here, like not the agenda per se, because we already have that, but the priorities would be to gain more territories, because in our interpretation of the clause, we did not have the right to sell in UK and Germany. So if the access were provided back to us, we could increase the market reach that Neha was talking about, and we could definitely, very certainly meet the 3,000 target. But seeing as how we are in a very volatile situation, the relationship is not as strong as it was in 2019, where we initially entered into the contract. So we would also like to lessen the number of non-cancelable orders from 3,000 to 2,000 or 2,500. That is something that we can work inside of. That is the limits that we would like to work in. And also, we would like to, because of this updates and upgraded this confusion, we would also like to have some confirmation that IBGF would have the rights to sell more games that are launched in the future. But I believe this could be covered in the future relationship agenda that Darius has already set. So all of this was just my concern. I believe that right now we are just I'm trying to understand where each other is coming from, because obviously our perceptions of the events have been very different. So I'm thankful that the other party is very honest with us, and let's see how it goes in the next session, in the next conference, sorry.
Thank you, Vijay and Neha. I think just quickly summarize what I heard from you is that you would like to reduce the minimum order quantity from 3,000 to 1,005. And secondly, on how IBGF
very sorry to interrupt, Vijay, but that was just a technical error. We would like to reduce it from 3,000 to somewhere between 2,000 and 2,500.
Sorry, 2,000 to 2,500. All right.
Yes.
Okay. So sorry, I didn't catch you there. And the second request is that IBGF can sell more, IBGF can be allowed the opportunity to sell more games and to distribute more games in the future. Am I right?
Yes, the exclusive rights to more games.
Thank you so much. So I think as I know that our caucus session is almost over, is this something that you would like me to reveal to the other party?
No, not really, because I think by and by, as we discuss the future plan, we will reveal it ourselves.
So for both reducing the minimum order quantities as well as the exclusive distribution rights for future games, both will not be reviewed. Thank you so much. So I think leaving this caucus session, I would love parties to think about, because in light of reevaluating your own positions, I would love parties to think about, what is your best alternative if you leave this mediation table today without a deal. And, with that at the back of your head, it will allow you to properly evaluate whether or not what the other party is offering, is beneficial to your position or not. So thank you so much. I think now we could move back into the main session. Madam Moderator, thank you. Hi, Ashley and Hillman. I think before we quickly summarize what Neha and Vijay has shared with us in the caucus session, we could now move into a private session with you as well, Madam Moderator.
Thank you, Madam Moderator. First of all, before beginning the caucus, I would just like to ask you whether you're satisfactory with the way the session has been going thus far, and are you comfortable?
I think we called the caucus because we weren't satisfied with how the first conference has gone. So I mean, physically I am comfortable, but in terms of how this mediation has gone, it has been far from satisfactory. So is it okay if I start what I would like to share?
Absolutely. Just before you do, I would just like to stress on the point of confidentiality is that this caucus carries within an extra layer of confidentiality. Therefore, you can be more honest and more transparent with us. Rest assured, nothing you say here will be divulged to the other party without your explicit consent. So please, is there something you would like to share with us which you couldn't in the main session?
Right. Thank you so much for for confirming and like clarifying that that we can be transparent here. I think first and foremost, we feel that it has been quite an aggressive first session, and I'm finding it difficult to maintain this spirit of mediation when it seems that a lot has been said by the other party, and very little space has been afforded to us to raise our constraints and raise the clarifications we want to raise. And on that note, it seems that this misunderstanding or this dispute really seems to be centering around the interpretation of the first clause. And it feels very unfair.
So sorry,
I'm so
Hillman.
sorry. Could you?
Sorry, before you move on, I think, oh yeah, okay, because the other
We're
party
good
came
now.
into the room. Yes, okay, we're good. You may
No, I'm so
continue.
sorry. The other party is still here. The counsel for the other party is still here. Yes, we're good now. Sorry, thank you.
All right. I was just saying how it feels a little bit unfair that IBGF seems to be pinning the entire non-performance of the contract on this one clause that was interpreted wrongly by them. It doesn't seem fair that we ought to be responsible for their, perhaps less than favorable strategic decisions. So it comes across as very. I'm just quite frustrated by how this by how this first session has gone. Ashley, if you could help me elucidate my thoughts better, I'll pass the time to you.
Sure. So maybe I could just add on to what Hillman has said. He has emphasized on how this entire issue so far has been really just a misunderstanding as to what really happened after the review. And so we would like to clarify here that the 4 months we took to review the contract had entirely nothing to do with what they mentioned on us not taking back their distribution rights. And so, we find it hard to understand as to why they thought that we were taking those rights back. And if they thought so, why there was no clarification, like following the review, there was no correspondence between our side and their legal side to really understand this matter further, especially since they're a distributing company. I would understand that distribution rights is something very important to them. And, that's the first thing. And the second thing to build on is that even if they did interpret it this way and made their decision subsequently, from what we know is that they agreed when we insisted on our rights to distribute as well. And I somehow fail to understand how their agreement to that supposed variation would mean that other terms of the contracts can be varied as well. If there was truly a difficulty in meeting those contractual terms of, let's say, 3,000 units, then why was there no communication between us on that matter? So, maybe Mediator, you could share, or Hillman, if you have anything to add.
Yeah, I think Ashley has done a fantastic job at trying to explain better what was going in my mind. And I think moving forward, mediators, if it would be possible, I would like to ask if the opposing side, if IBGF could perhaps be a little bit more considerate in breaking down their points, because we we do want to understand their concerns and their positions, but in the manner that they've put forward those interests, it's a little bit difficult for us to take on everything at once.
Absolutely. So we will definitely facilitate the conversation better in a more structured manner to help both the parties understand each other's stance better and to hopefully arrive at an amicable solution. But unfortunately, our time for this caucus is over. So Darius, unless you have any other questions, we could perhaps call the requesting party in and again resume the joint conference.
Thank you, Taylor. Just maybe some closing remarks. So I asked IBGF the same question before we left this caucus session. So I think parties, when re-evaluating your positions, as well as the other parties, as what we spoke about earlier in the opening statements, I think it is important that we do it with the background of, you know, what is the alternative that we will have if we leave this negotiation table today without a deal? And that will allow us in putting things into perspective and to, you know, just to evaluate whether or not the deal that we have at the table is beneficial or not. So I do hope that parties will keep this in mind. So thank you for your time in this private session. So Madam Moderator, could we move back to the joint session?
Sure. Just a second.
Hello, Neha, Vijay, and now we are all back in the main session. I would like to, tell parties how I feel that it's really heartening to see parties still at this table today, trying to work out an amicable solution that we are all happy with. So before I proceed, and before Taylor takes on to tell us what has been said in the caucus session with Ashley and Hillman, I would like to remind parties that mediation is a two-way street, and while we want to share our constraints and struggles with the other party, it is also very important to hear that of the other parties as well, because most certainly we are in this mediation on this mediation table today, wanting to come to a solution that we are all happy with. So, and that necessarily includes and encompasses the constraints and the struggles that the other party faces as well. So, Taylor, could you just assist us in telling us what Hillman and Ashley has shared in their caucus session?
Thank you, Darius. What Darius said is exactly what I was going to, in fact, tell you, is that mediation is essentially about listening to the concerns of the other party and evaluating them to come to a mutually acceptable solution, which also aligns with your interests. In accordance with that, from the caucus, which was extremely beneficial to both Darius and I to understand what you feel this, like how you feel session is coming along. Both Darius and I feel that this session is running on two parallel lines. One line is focusing on clause A of the agreement, which is talking about the argument of updates and how it will be interpreted. And the other line, which is is being focused on the right, the distributorship and the selling of more, or like, I'm so sorry, the number of units that were being sold, the minimum number of units. So I think to structure the session a little better and for the convenience of all the parties involved, perhaps we could just take up one of those lines at a time. We could just start with the interpretation of the word updates, if that is a point of contention and if it's acceptable.
Sorry, can I just clarify that we're talking about the term updates in clause A of the contract? Okay.
Yes. Since it seems like a point of contention to both you and Hillman, as well as Vijay and Neha.
Actually, I'm sure that during our caucus we didn't actually bring up this point on updates because just briefly saying our caucus was really mainly about the misunderstanding between the review of the 4-month review of the contract and about sole distributorship rights. So if you could just help me understand this disagreement on the term updates.
Absolutely. So from what I noticed in the caucus, you sound a little troubled and a little frustrated with respect to the way updates was being interpreted, which was in fact causing a hindrance to talking about the way the distributorship agreement and the breach of agreement is being taken place, which is why I thought that it would be helpful if we could clarify this.
Oh, I see. Okay, so maybe if I could just clarify what I meant when I brought that up. So, what we wanted to say was that there seems to be a misunderstanding between our end and IBGF's end on what really happened during the 4-month review after signing the agreement, of which I think in the earlier session, IBGF mentioned that we retracted their distributorship rights. And to that end, from what we understand is that we did not. And so I don't think it was really a contention about the term updates, but just really whether or not there was a retracting of the distributorship rights. Hillman, do you have anything you want to add on this?
Yeah, certainly. And it was also a matter of communication, I think, that we brought up, because after that 4 months, and after we had reiterated rather our right to distribute the GRA series, there was no communication from IBGF disputing this right. If in fact they had agreed to it. So I think that's the point that we were trying to raise during the caucus. And if IBGF could help us understand how this interpretation came about, and perhaps share a little bit about how this interpretation had affected your business strategies, that would be fantastic.
Yes, surely, Hilman. So from our perception, and please just ask me to repeat myself if you still feel that I'm going a little too fast. I'm very apologetic about the same. So from what I understood is, when you restrain the rights, when you retain the rights to exclusively sell in UK and Germany, we at IBGF felt that we were not allowed to do the same. Like, we were not allowed to directly sell in Germany and UK. And when that happened, when you retain those rights, there was no official change in the agreement. So that is the point of, I believe, the miscommunication, that we could not sell. We were not selling in the Germany and the UK. We were only selling in India. And that is why we could not reach the 3,000 target that we had. So if you could just please, and I would request Ashley and Neha to please just confirm that when you retain those rights, you did not preclude IBGF to sell in UK and Germany. Rather, it was just Boxstar and IBGF could sell it together, or if I'm correct in that regards. I believe Neha could put forth what I just said in a more succinct manner.
Yes. So as Vijay already mentioned, when Boxstar insisted on retaining their rights to directly sell in Germany and UK, essentially IBGF was restricted in terms of their market reach, because of which they could only sell in India, is how we had interpreted the clause. However, I think instead of circling around the interpretation, we could more focus on our future and developing a more amicable relationship, and talking about the damages that we could settle upon. And also, I think IBGF is ready with a business plan to propose, to put forth, to work with Boxstar. How does that sound to you, Ashley and Hillman?
So from what I'm hearing, I would like to first confirm that when during the review, we did not retract any distribution rights for IBGF to distribute in Germany and the UK. So I hope that clears the air on this misunderstanding. And then, there seems to be a point of communication, and I think for that, my client Hillman might be able to throw out some ideas there?
Right, certainly. Thank you, Ashley. And thank you so much, Neha, for proposing offering to propose to table an offer move for the business relations moving forward. And I think that it is important that we realize that I think that communication was an issue.
So sorry,
I'm so
Gilman.
sorry, Hilman. You're not audible. Your I think mic is lagging. Can you check your connection and get back to us, please?
Can't hear
No,
you.
I'm so sorry. You're not audible. No, the meeting link is in the chat box. So perhaps you could rejoin. We will pause the session for you.
Hi, am I audible now?
Yes, you're audible.
Thank you so much, and
However, we cannot
apologies
see
for.
you.
Okay,
That's
thank
all
you.
right.
And apologies for the internet connection. Not sure what's going on. As I was saying, just now, I think we realized that communication was an issue, and I think perhaps before we move forward with the business proposal that Neha and Vijay has offered to table, we could discuss a framework that could ease communication between parties. I think first and foremost, I would like to thank Neha and Vijay for offering to table that offer. But personally, I feel that as a company and business, as a profit-driven company, it would be quite beneficial to get the foundations out of the way first, right? So perhaps this communication framework could come in the form of fortnightly updates between the two parties regarding anything that could be in contention at that present point in time. So perhaps if it were like a contract issue, if it were a sales issue, or if it were a distribution issue, all of that can come in a in these sort of updates. I'm more than willing to. I'm more than happy to listen to what Vijay has to say with regards to the medium that these updates can be. So perhaps maybe like a video link or a report, or whichever is of more convenience to you.
Thank you, Human, for the wonderful option that you have came up with. If parties are okay, could I just share my screen so we are all on the same page as to what we have on the table right now. So a communication framework and what Human told us, fortnightly updates between parties regarding any, you were saying contentious issues. Could I check, what do you mean by contentious issues?
Perhaps I wasn't clear on that. I think I just meant the issues that could be more pertinent to that point of time. So it could be like, a sale issue or, whichever is more contemporary. Thanks.
Thank you, Human, for your clarification. Perhaps now, Neha and Vijay, could you maybe share with us, how would you like this communication to be this information to be relayed over to the other party?
Yeah, surely, Darius. I am more than happy to agree to the fortnightly updates, Hillman, because as we have just come to understand that there have been certain miscommunication and misinterpretation of certain clauses. So a fortnightly update sounds really good to me. And as regards to the method of communication, seeing as how you are based in Bangkok and we are in New Delhi, I believe that something along those lines of the Zoom meeting or a report, as you mentioned, I'm more than happy to agree to either of them. I believe that I would like to hear what Neha has to say on this regard.
Yes, so that sounds like a very good offer. We could have fortnightly updates in order to clear any miscommunication that we're having in front of us. In fact, even IBGF was all the more ready to do the same, to review even the sales targets at least quarterly, which could support the business to improve. And essentially, the mediums could be any virtual medium. That's all I have to say. How does that sound to you?
On this point, maybe I could just add a little. So I was thinking that a virtual conference via Zoom, as the other side has mentioned, would be a really good idea. And maybe on lengthier issues, a report might be more suitable, given as to how this entire miscommunication really happened on paper. So I think virtual conferences where we could really just speak to each other and be transparent on the concerns on each side would be good.
Thank you, Ashley. So what I'm hearing is that virtual conferences for quick updates and reports for no lengthier updates. May I check if this is parties are agreeable with this?
Yes.
Written reports. Okay. No, because we want to ensure that some finality to mediation. So perhaps we could also flesh out this option slightly more and think about what manpower is being involved in this?
Yeah, certainly. I was thinking that my head of marketing could take control over this, seeing as to how it is a matter of distribution and perhaps matter of business strategy. I think this could be this could be my head of marketing could be quite suitable for this. And I think that also it's quite flexible as to who else could be added into this, because if it is a legal matter, I think I would be quite happy to have Ashley attend these meetings as well. So if this is something that IBGF could share their concerns, if any.
Perhaps IBGF could also, sorry, perhaps IBGF could share with us, who would you like in your company to be like a primary point of contact? I think that would be good.
Surely, Darius, the primary point of contact from our company, I would say, would be the COO of IBGF, along with Neha. And in the absence of Neha, anyone that Neha is trusting of, I believe that would be someone that I can entrust with to deal with such intricate matters. Also, Neha mentioned some quarterly updates regarding the sales. So could we please add that if that is agreeable to Hillman and Ashley?
Yes.
Small clarification here. I'm so sorry to interrupt, Neha. Vijay, if you could just clarify if you mentioned the CEO of IBGF or the COO of IBGF.
Oh, sorry. It was the COO, Taylor. It was the COO.
Thank you so much. So I think if parties are agreeable with this communication framework that we have on the screen right now, I think it's safe to say that we do have an agreement on this. Is there anything else that parties? Yes.
I believe that I could not hear what Hillman had to say on the quarterly sales updates. I would really like to hear what he has to say.
Most certainly.
Thank you so much for remembering that. So the quarterly sales updates I think it would be much appreciated, and perhaps as a sub point to that, if IBGF seem to face any obstacles with regards to the sales update, with regards to the sales requirements, I think those should be highlighted as well, because we want to maintain our partnership with IBGF, so we want to help each other. Help each other. So it would be great if we could be more understanding, or if we could have a better understanding of the situation that IBGF might be in at the current point of time.
Yes, of course, Salman. I believe that is a really good solution to the communication issues that we have been having.
And mediators, if this is if it's amenable to the mediators, I think I would like to also discuss the proposal that Neha and Vijay had brought up earlier. Is that okay with you?
Most certainly.
Yes, absolutely. If Neha and Vijay
Sorry,
are comfortable.
Taylor,
No.
could you just help us in wrapping up this this solution that we have at hand before we move on to the next solution that Neha and Vijay would like to propose?
Absolutely. So here we're looking at the first proposed solution, which is the communication framework. First, which was agreed to, was the fortnightly updates between the parties, either that may be over a virtual conference or a written report, and the quarterly sales updates and the concerns relating to the sales quota will be communicated in the future. Furthermore, the major point of contacts in both the parties, first in Boxstar would be the head of marketing, and second in the IBGF, it would be the COO and Neha collaboratively. Have I got this correct?
Thank you so
Yes,
much for a wonderful summary. I'll just put that into the chat right now. I will just put that into the chat right now, and perhaps you can move on to talk about the next solution that we have in mind.
Neha and
Yes.
Vijay, both of you are comfortable.
Yes.
Yeah, surely. So, okay, sorry, Neha. So what we have in front of us, what we had in our mind and would like to propose on the table is a long-term plan, which would be encompassing 5 years. We have chosen this figure because we need some substantial time to see the returns and the profits, because as we've already cleared up the miscommunication regarding the updates or the upgrades and whether Boxstar restrained IBGF or not. Thank you so much for that, Hilman and Ashley. So now I believe that we can go ahead with the future relationship. So Neha really has helped me with drawing out this very detailed plan over the 5 years about how we will go about the sales and where would we be selling. So two major distributor points, if the mediators could please note this down, is in the UK, we have two major distributors in London and in Bristol. So we have our major distributing chains there, and we have sub-distributors in relation to that. And in Germany, we have one in Munich and one in Frankfurt. So if that is agreeable to Hilman and Ashley, going to the future, as Neha will explain the 5-year plan, we could sell the GRA2 series. Since you have discontinued the GRA, like the original series, we could distribute it from there. If you're agreeable to this, I believe Neha could please go ahead with the detailed 5-year plan.
Maybe I could just
confirmation. Yes, please go ahead, Ashley.
Oh, no, it's okay. You can go first. Yeah.
I was just about to confirm what Vijay just said, is that you have two major distributors in the UK. One is located in London and one in Bristol. And in Germany, you have two major distributors too, one in Munich and one in Frankfurt. Besides this, you do have other sub-distributors. Did I get this correctly? Thank you, Darius.
Yes, Taylor, you did.
So sorry, Ashley.
Right, thank you. I was just about to jump in and summarize this for my clients. So I would like to just clarify. So on top of the 3 distributors that you already have in India, these will be the 4 additional distributors. Am I right? So that will come up to a total of 7 distributors now?
Yes, Ashley.
We are a global company, so we already have established networks in UK and Germany. And specifically for the gaming series, we have a plan which also includes more dealerships, which I will propose shortly.
Sorry, could I just check? So sorry, could I just check with Neha and Vijay that I can include the 3 major distributors in India as well in this plan?
Yes. Darius, the 3 major distributors in India, 2 are in Mumbai and 1 is in Bangalore.
Sorry, can I check Bangalore, is it?
Yes.
Okay,
2 in
thank
Mumbai,
you.
1 in Bangalore. Thank you. You're most welcome.
Hi, if I could step in, if I could chime in. I heard that Neha did propose, and Vijay, like that this would be a 5-year plan. And I know that IBGF is a growing company and a relatively young one as well. So to my mind, at least, I don't see why we should be constrained to these 3 territories as well. So perhaps with regards to the distribution network, this can be renegotiated every year as part of this overall 5-year plan, because I think that I am hopeful that we get to grow as companies together, and we would be unwise to limit ourselves to these 3 areas. What do you think about that, Vijay?
Hilman, I believe that the offer that you put forth of renegotiating yearly is really sound in my opinion, because yes, we do not want to restrain ourselves to the 3 major distributors that we have. As you said, that we are a growing company and we are looking to have new markets in the Asian country and in South America too. So yes, I'm completely on board with the renegotiating yearly. I would like to solicit Neha's advice on this also before I continue.
Certainly. So as my client put forth, the yearly review would be great. And also IBGF is looking to expand and tap markets in Asia as well. So that would be a great opportunity.
Right. On that note, I perhaps, in supplementing this, expansion of the distribution network, we could also consider the milestones that need to be reached in terms of sales before we feel ready to expand even further. So perhaps Vijay, you could help. What are your thoughts on this?
Yes, I believe now would be an opportune moment for Neha to actually share her screen and talk about the 5-year plan that we have been talking about for the last 10 minutes or so.
Yes, before that, just a small clarification. I just wanted to know how Boxstar has been performing in the UK and German markets before we actually proceed to the 5-year plan.
Right, certainly. I don't have the numbers on hand at the moment, but I would be more than happy to email it to you, following the conclusion of this session. Can I ask how our numbers would affect your plan?
Just wanted to know how, based on the existing reach, we could probably plan a better way ahead. However, I would presently plan right now, and based on the mail, we could review it later on.
Sorry, if I may quickly chime in. I do note that we have 5 minutes left on the clock. So maybe parties, before we move on any further, we could just take a look at our distribution, our proposed distribution plan again. I do note that parties want it to be 5 years. So could I check how does this 5 years look like in specific? If Vijay and Neha could clarify on this point. Are there any specific tranches? Is it broken down into tranches, or it's just a distribution network that just spans over 5 years?
It's a distribution network for 5 years, and the contract can be renewed every 5 years. So the reason we took up 5 years is because based on our experience, it takes at least 3 years for our returns on investment to be back from the dealership. So this is the reason we've taken 5 years, and it could be renewed every 5 years. That's the plan.
Thank you so much for the clarification. And I do hear from Hilman that you would like to put some sales milestones in place as well. Are Neha and Vijay okay with exploring that very quickly before we wrap up this session?
Actually, Darius, I believe that if we could just go over the 5-year plan really quickly, then we can actually talk about the sales milestones.
Of course, most certainly.
If I could maybe just chime in here, I note that, as much as we don't want to talk about the dispute that brought us here, but I think one of the points was the setting of a minimum annual order. So, given as to how the distribution would require some orders from IBGF to us, maybe we could also take the opportunity to discuss that. And, if we could tie in the minimum annual order to this distribution plan, then I think it would be a really good solution that will meet both our interests.
Most certainly, Ashley. I am also very agreeable to adding the minimum annual order. And this is also covered, I believe, in Neha's plan that she will be sharing shortly.
With the 3 minutes on the clock, perhaps Neha could just briefly bring us through your plan, and we can put that down in our partial agreement.
Yes, Darius, if I could share the screen.
No problem.
Yeah. I hope you can see the screen. Yeah, right. So this is a proposed plan for a period of 5 years, as I already mentioned. So starting in the first year, assuming, so we have arrived the figures based on the counterclaim, which was made by Boxstar, and also the products we've purchased. So based on the value of that and the amount of sales that IBGF has done in India and in other countries, most certainly in the future. So this is specifically with India because we have 3 distributors in place. So starting in the first year, we have 3 dealerships at hand right now. So we would be aiming at a target of $750,000, which is roughly around 3,000 units. So this is the plan which is there for the 5 years, taking the cumulative revenue to around $3.75 million. And with respect to UK and Germany, this is our plan. We are slowly trying to expand both in UK and Germany. So I think the figures might take some time for me to explain, but I'll just quickly run you through the cumulative aspect of it. So cumulative sales in both in Germany and UK would be around $1.05 million. To be more clear, the total revenue that we're aiming in India, UK, and Germany in the next 5 years would be around $5.85 million, which is quite more than what target we had set in the present agreement. And we are looking to, we're also proposing a customer feedback mechanism, which I'm not sure if the mediators could help me how much time is left so as to put forth that.
We actually do not have any more time left in the clock. I think really nicely, I think your plan is wonderful. I think this nicely overlaps with the proposed subheader under the distribution plan of sales milestones. So if maybe I could change this to sales milestones and forecasting, because this seems like a forecast of the sales that IBGF has proposed. Yes. So if parties are amenable, we could leave this, we could take a better look at this sales forecast in our next mediation session. And I think we have managed to cover a lot of ground today. Perhaps maybe Taylor could help us summarize what we have covered today and what we are left over with.
Absolutely. I think, Darius, for a more audio and visual view, could you share your screen too?
Most certainly.
Thank you. So over here, we've come to 2 proposed solutions. The first one was the fortnightly updates between the parties regarding any issues that may be pertinent. And these updates can be through virtual conferences, through Zoom, or a written report. Furthermore, the quarterly sales updates and the concerns of the sales quota will be communicated in these. Next, the point of contact in both Boxstar and IBGF will be for Boxstar, the head of marketing primarily, and for IBGF, primarily the COO and Neha in collaboration. Coming to the distribution plan and the distributor network, the distributor network will be reviewed yearly. In UK, currently, IBGF has 2 major distributors. One is based in London and Bristol. In Germany, they again have 2 major distributors, one in Munich and the other in Frankfurt. In India, they have 3 major distributors, 2 in the city of Mumbai and 1 in Bangalore. besides from this, you also do have further sub-distributors, and you also are hoping to explore more and find more distributors in Asia. Um, Along with this, the timeline which is decided is 5 years, which will be reviewed after every 5 years and a meeting for this review. And lastly, for the sales milestones and forecasting, we have the business plan, which Neha recommended right now, and as well as the minimum annual order, which was agreed to. This sales plan, like Darius mentioned, the details of which and the discussion on which will be taken up in our next session. Did I miss anything out?
Thank you for the wonderful summary, Taylor. Maybe you could tell us what we have remaining on the agenda that we can talk about in the next session as well.
Absolutely. I think we have not touched upon the bit about the damages and the financial concerns. Along with, I think we've also established quite a lot. We've made a lot of progress on the establishment of a distributor network, as well as the minimum order amount. The outstanding unpaid sums will also be revisited. And I think the prolonging working relationship, we do see it happening with the updates, fortnightly updates, along with the revisiting of the business plan. So I think this prolonging working relationship is still a work under progress, but we have made significant progress in this.
Thank you so much, Taylor, for helping us sum up this session so nicely. I think in this mediation session today, the spirit of collaboration has definitely burned bright. Parties are really amenable and also very collaborative in coming up and bettering the options that we have on the table. So if parties are okay, could we schedule our next session on the 1st of April at the same timing? Thank you.
Certainly, sorry, Darius. I would like to, I mean, if before it slips my mind, I would like to, like on the point of prolonging working relationships, could I add just a little bit with regards to future partnerships with perhaps other distributing companies? I think this would really give parties a lot to think about before, before we move into the next mediation session. But on the point of the next mediation session being set, yeah, we are okay with that date.
Thank you. Is Neha and Vijay amenable with this update of the agenda for the next session?
Am I audible?
Yes.
Okay, thank you. So I believe we would require some clarification on the newest agenda point that was added, but seeing as how we have run out of time, I think that in the next mediation session that Darius is already scheduled for us, so kindly we can take that up. And I believe that even though we still have a lot of agenda points to touch upon, we are in a better position that we understand each other's concerns, and most importantly, the misunderstandings that we had, we cleared that out of the way. And I'm really thankful to Hillman and Ashley for understanding where we were coming from and confirming that some of the misunderstandings that we had did not hold any water to themselves. So I believe we had a really fruitful session indeed, and all the rest of the points that we are left with. And I'm also very sorry that we could not go over Neha's detailed plans because of the paucity of time. But in the next session, surely we can go upon it. And of course, I do see us having a very bright business relationship ahead.
Also, if I may, I am very happy and grateful for having arrived at this stage in the process. We could discuss the financial concerns, the business plan, the minimum annual order, etc. in the next session. Ashley and I can meet up over a cup of coffee and iron out the terms of the contract and also work out the business plan together later. Thank you.
Thank you so much. Hillman, Ashley, if you would like to give some closing remarks.
Yes, I think we are very grateful that we managed to overcome that quite a interesting obstacle, if I could put it nicely. And yes, we are certainly very committed to continue to work with IBGF because we saw the potential that IBGF had when we first engaged you, and we will be more than happy to make sure that that potential, we meet that potential together. So yes, certainly I would be more than happy to continue discussions about the rest of the agenda points. But yeah, I think overall I'm really excited moving forward.
Yeah, so like as Human has said, that we're really very happy that we managed to overcome one of the biggest obstacles that we came here to settle today. And Neha, I'll be glad to have a cup of coffee with you one day and we could talk about the contracts. And I look forward to really working with IBGF in the future, talking about, and if we have any concerns, legal concerns, or any business concerns in general, that I'm pretty sure Human and I are more than happy to look towards the future and build better relationships together. Thank you.
Darius, why don't you go ahead and then I'll wrap up this session.
Thank you. I think today has been a really wonderful and fruitful session. We may have occurred a little bit of a speed bump earlier in the session, but definitely after we went to the caucus and parties shared with us their concerns, the whole session managed to run really smoothly. And I think Taylor would have agreed with me, as co-mediators with Taylor, this session it's really heartening to see how parties are, they have embodied the spirit of mediation. And looking at the proposed solutions that we have came up today, I think we have made a lot of headway in the problem that brought us to this table this evening. And parties were really keen on exploring each other's solutions and to better it. And as a mediator, and I've been in many mediation sessions. I think this is one of the mediation sessions that we have made where significant headway has been made in just the second session. And in the third session, I'm very, very sure that we will make even more headway and agreements will be made on the 1st of April. And thank you so much, parties, for your valuable time. If Taylor could assist us in wrapping up this session.
Thank you so much, Darius. In fact, I do agree with you. The parties genuinely showed very great effort and good faith at open communication. And I sincerely do believe that we made great progress today. And I'm confident that, in fact, in your next session, more of your concerns will be resolved. So the agreement that we've all reached today is in fact very positive. And like Darius mentioned, it is very rare that in just the second session, such headway can be made. So we're pretty sure that your future interactions too will be in such positivity. Also, the 3 drafts that Darius and I have made will be emailed to you. So you do also have a copy of what was proposed today. And the concerns left unresolved will, of course, be addressed in the future mediation session. I wholeheartedly thank the parties for their cooperation. And thank you and good night. Have a nice day.
Thank you.
Thank you, participants. Before we go to the feedback session, can everyone turn their cameras on so that we can take a snapshot? Okay. Thank you so much. Now the judges can provide their feedback to all the teams.
Well, I'll talk first. I wanted to thank you all for such a wonderful session. I've been looking forward to the final round since I started. Here you are, and here we all are. I'd also like to thank Maureen Robertson Eric Shaw for Maureen Erickson, Robershaw, excuse me, for her wonderful problem. When I was reading it as a judge, I was like, whoa, this problem has a lot of layers. And I thought the mediation, you kept up well with all the factoids in this problem. What I'd like to do is do an overall of the mediation and overall of the client advocate situations, and then go into some of my personal comments. I've actually put my email on your score sheet, so you can talk more to me about it if you'd like to ask more, because I want to be sensitive. I have a lot to say, and I don't want to say it all because I have other judges here with me. So let me start with mediators. You have two goals of mediators at any mediation, and no mediator, we don't know where it's going. None of us. We can do hundreds of mediations, thousands of mediations. We have no idea where we're ending up with parties because every mediation is always new. The one thing you're doing is you're chasing accuracy at the mediation table, people's positions and facts, but you're also building a relationship. The way that you build a relationship at the mediation table is you hear them, you hear what the parties have to say. And the way you have to prove that you hear them, the way that you prove that you hear them is you reiterate in your summary the words that you heard the counsel and advocate say. So that means that when you are mediating, you cannot just bond with the facts and say, this is what I heard you say in these 2 or 3 things. You have to bond with their story as well. So your summaries after the opening statements should be rather long. If they've given you a long summary, you need to have a long mediator summarization of reiteration of what they told you at the mediation table. Secretly, that also allocates responsibility to them as well, that you can use later throughout the mediation, because when you reiterate their words, you actually allocate responsibility, and you can refer back to that. And also, moreover, they can clarify you as a mediator. Clarification of a mediator being corrected at the table, you want to feel totally comfortable with it because you're chasing accuracy. This mediation was about a confusion. So the first thing we have to do is agree to what's being confusing to both parties. And as your mediators, that was your job, to go into the confusion word to say, how is this confusing for you? How is this confusing for you as well? And to get agreement on the confusion was the meta part of this mediation from the very beginning. And because it wasn't addressed clearly at the beginning, it filtered all the way through the mediation. And you heard the client say all the time, we're confused, we're confused, we're confused. So these things can be addressed quite up front. We have this beautiful burden as mediators of establishing clarity. It's a beautiful burden, and we have to chase the clarity as well as accuracy at the mediation table. Being a mediator is not correcting. I heard a lot of soft corrections. When you correct a party on this is what mediation really is about, you softly and quietly become the judge and referee of your mediation process, which is something you never want to do because that compromises the neutrality of your mediation process. So you want to think about how often you are correcting a party and why are you correcting and how you're correcting if you need to do that at the mediation table. The mediation table, lastly, is also a beautiful blend about being pragmatic and logical versus being emotionally bonding with the parties and intuitive. Every mediator has to figure out their percentage. I saw, Darius, a lot of logical in you. You kept this process so smooth with your numbers, your figures, your factoids. You did a lot of that. You're really strong in the pragmatic process of this mediation table and clearly with your thinking, and you want to work on your percentages being warm and bonding. As Taylor had the more warm bonding side with the mediation, Taylor's even apologizing for misunderstanding something, which is always super appropriate to do at the mediation table. Everyone will forgive us as mediators if we don't have to apologize too many times, but I literally say I profusely apologize for misunderstanding that. So Taylor, you've got this warmth to you and this bonding to you, and you're kind of sinking into the beyond of what you heard. You use a lot of reiteration words in your summaries, which I thought was very, very good. And the clarification that you had was excellent with your words and comments. And Darius, your clarification was excellent with your logical and your charts and your this. And the co-mediation team, I don't think I've seen it done better in a tournament. You refer to each other. Would you do this? Can you do this? Can you end a session? Can you clarify this? I gave you just top scores for your co-mediation work. As we went into the caucus, two things coming out of the caucus. Does anyone need us to note what you don't want us to share when we return to the joint session? I don't think I heard that question in either caucus at the end when you're leaving. It's very important to find that out. Otherwise, what's the point of 100% confidentiality and the extra layer of the caucus? And also, I'm not so sure I heard strongly, both in the opening, does everyone have the full power to make decisions here, have the full authority, continuing to have the full authority without contacting someone else, which also relates to the caucuses, because you also want to have the full authority to talk about everything that was said in the caucus. So what you want to know from the caucus is what can't we talk about? So these judges' comments are both to encourage you and tell you what you did greatly, but also to get you ready for your next tournament, because there's always a next tournament, right? So Taylor, you got into a little bit of trouble when you started using words from the private session. And you actually said, you seemed a little frustrated. So I thought it would be helpful. And there's that warmth coming out, but you were in trouble because of the fact that you didn't find out what you couldn't talk about returning to the joint. So therefore you were corrected by the client. Well, I actually didn't mean that. And so now we're chasing accuracy, but we're not chasing accuracy because you've drawn it out of the clients. We're chasing accuracy because you've said something a bit out of turn in the joint session. And now the client's like, uh-oh, now I need to restate myself. So these are the kinds of things that can happen when you're coming out of the private that you don't want to have happen in the mediation sessions. I love judging this final round. I thought everyone was absolutely fabulous. I scored everyone very closely, and it was really a pleasure to judge. Moving on to the teams, I just really thought that the overall strategy was, this is what it looked like to me. We're negotiating a contract because we had a double start here. So when you're looking at your strategy as a negotiation team, as a client counsel team, when you go back to the beginning of the general facts, we had this agreement, but then it went under review, and then, the agreement's changed. What's going on now? So basically, the clearing up the misunderstanding is the first thing that needs to be understood clearly. And then releasing the facts doesn't always clear up the misunderstanding, which again tethered and was a vein of communication all throughout the mediation. So basically, finally, I heard that how question. How does our numbers, how does that look like for you in your question about your business? That's that how question. How does this confusion between us after it gets named, how does this impact you working with us? So that's the overall strategy that I saw. And when I looked at the client advocate teams, it was very, very good. Very, very good. We actually had Hillman ask the question, could you please slow down your talking, which is actually a mediator question as well, so we can all understand. We had Hillman and Ashley basically say, we're confused, we don't understand. So they're grabbing more information with those questions. We're not sure, no, this is not quite what we said. So that your team 41, you were really pulling a lot of the mediation. And I just thought, team 2, that you just were so nice and so wonderful. And you just had you had a sweet presence at the mediation table, a lot of willingness after the initial joint opening statement, where there was a lot said. The thing at the mediation table is people think if you're talking the most, you've got the most power, and that's actually not true. So you want to think about that as well. So let's go ahead and let our other judges speak. Thank you.
Thanks, Kathleen. I think I'll go next. I'm just going to stick to the positives, which, sort of spoke out to me. Coming to the mediators, Taylor, I agree with Kathleen when she says you were so humble during the entire process, and that definitely added to the process in terms of warmth and all of that. I felt you were very professional, and at the beginning, during your opening statement, you made the entire process very clear, explained it so well. So I think that added to the comfort of the parties on what to expect, what's going to happen in the process. So I think that worked really well. Darius, I love the fact that you were so patient throughout the process. You inspired a lot of confidence within the parties and you were approachable throughout the process. And I love the fact that you made an effort to ascertain the concerns of the parties throughout the mediation process, be it the caucus or the conference. So that really stood out to me. Then coming to the client and counsel team, I think the counsels and the clients shared a very good rapport with each other. The only thing that was an issue for me at the beginning, maybe during the first conference, was the fact that although the counsels were very protective of their clients' interests, but it sort of, gave an impression that the entire process was going to be adversarial. So I think the fact that there was some issue with the trust formation between the parties, but I think that can be expected, especially with the first conference. I'm glad it was restricted only to the first conference. And after post the caucus, things were more better. I think the communication was there. It was there was constructive communication between the parties, and I'm glad everybody sort of came to a conclusion where it felt things could move on to a better settlement, maybe in the next mediation session, which you've sort of scheduled. So all of this really worked to me. The concerns, I had some concerns in the caucus. I would agree with Kathleen, agree with whatever she said about the caucus. So those were the concerns that I also had, but she's talked about all of it. So thank you so much. It was a pleasure judging all of you. It's been great. Thanks.
Garima, would you like me to go next?
Yes, sir. You can go next.
So first of all, though, I would like to congratulate all the participants who are here. It's by itself an achievement that all of y'all have reached here. End of the day, one team will win, one team will not win. But reaching where you are right now is a victory by itself. So you guys should take a lot of pride in that. I totally agree with Kathleen and Amrita's comments. We just need to understand that what is the need for a mediator to be there? See, these parties know each other from much before the mediator steps in. They've had a cordial relationship and then they've had an adversarial relationship. So the need of a mediator to be there is to get them to cut down a conflict, to resolve a conflict. And for that purpose, there are two very essential facts. One is that the mediator needs to know when to take a back seat. And when he sees that it's not working while taking a back seat, then the mediator needs to, at a certain level, strategize and make the discussion follow a route which is in terms of the agenda or the issues in dispute. So I think the mediators here also did, both of y'all, M41 as well as M02 made a great thing by, placing the people back on the points that were up for discussion and guiding the conversation, summarizing the points well enough for parties to understand as to what they've committed to, what they've realized, what they've not realized. But a certain bit of more structuring, especially when the parties tend to go a little overboard with their feelings or with the contentions that they have, that is the point that you need to just take a little more step in and get the parties back on track as to why they are here. And once it goes on smoothly, then you can obviously take that backseat. With regard to the caucus, I absolutely agree with Kathleen, because it is very important to know what is confidential, what is not confidential, because once you give out something which is confidential, it may be used in a wrong manner at a later stage of time in case the negotiation doesn't go through. So that is a line that needs to be drawn and strictly followed. With regard to the parties, I think so the client councils, they did an exceptional job. The councils tried to represent their clients to the best of their abilities. The clients represented themselves pretty well because end of the day, it was their cause which was at stake. So it was a wonderful experience judging, and thank you all.
Thank you, sir.
Hello, so probably I will go next, and I'll try to keep my comments short because we're coming close to the closing ceremony. Well, thank you very much for having me today. It was really a pleasure, a really huge, I cannot tell you how happy I am that I was here today listening to you. And it's really heartwarming to see you all so skilled up and practiced and doing so well. So congratulations to each and every one of you for your performance tonight. So a lot has been said already, and I hope that you've taken note. I really like that. So I think the atmosphere was good generally. Yes, as you've heard, there were times where we felt that it was a little bit argumentative, but I think you felt that too. And in some aspects, I think it's normal because there has to be that venting out, which is good because it happens at the beginning. Then you've cleared the way for progress and for resolution. But generally, I felt that the atmosphere was good and I really liked the progress towards the end. I felt that if this continued, we would have reached a solid settlement agreement. So I'm not sure I can provide individual feedback. I do have individual feedback, so please do reach out afterwards. It's just because we don't have much time. But just some general feedback. I really liked the assurances that were given. I felt that they were very effective coming from the mediators. That made the parties open up and talk freely and vent out at the beginning, and then slowly, having released those emotions, come into a more solutions-focused position. There were some general points of improvement that I would, just point out here. And that's probably the counsel in me that noticed that. And those are things that I really work on and try not to do. So for example, when the words breaches were used, I would use alleged breaches. I think it's okay to use breaches, but please use alleged breaches because we don't want to be sound too accusative. And there were also a lot, there was, I think, too much use of the word but, and that's something that we try to use less of, and use words like and, or unfortunately, and other less confrontational words. At some point, somebody used the word dubious. I do not remember who it was. And I felt, okay, so maybe you could say something like, it may likely not be this, or it may likely be considered to be this, that, or the other, as opposed to coming up with a very strong word, even when you're venting. That's about it from me. I think you've received a lot of feedback. So like I said, please do reach out. It'd be great to continue to be in touch after we've announced the scores, and we can be, we can speak to you individually. Okay, I wish you all the best because like has been said, there will be other competitions. All the best, and see you soon in 5 minutes to announce the scores.
Thank you so much, judges. Thank you so much, participants, for being there this final round. You can all stay back here because we'll have the closing ceremony in approximately 5 minutes over here, and we'll be declaring the judges in this session only. Thank you.